Hello and welcome to this Anil webinar linked to an article that went live on the Lancet website last night, UK time. It's titled Increasing Compliance with International Pandemic Law, International Relations and New Global Health Agreements. I'm Jessamy Bagenal and I'm a physician surgeon and a senior executive editor at the Lancet. I remember when some of the people on this panel reached out about this article, it served such a simple and very clear and necessary purpose. We were immediately interested and could see the importance and impact it could have on the pandemic treaty. Happily, peer reviewers all agreed. In May 2021, the Independent Panel for Pandemic Preparedness and Response recommended a pandemic framework convention. And later that year, in December 2021, 194 countries agreed that a new pandemic treaty was necessary. At that time, it felt seismic. And in preparation for this webinar, I reread a health policy piece that was published in the Lancet Public Health by Jonathan Duff and colleagues in May 2021. And that laid out a vision of what an accord could look like. And at that time, it really seemed possible. Ilona Kickbush described this vision as everything global health advocates have wished for. A forceful WHO-like global entity with a capacity to coordinate recalcitrant governments, launch large-scale operations, enforce international rules by providing incentives and penalties, frankly assess the adequacy of national health systems, and provide technical advice free from the vagaries of scientific uncertainty. But the process has been predictably challenging, with many obstacles. The optimism and energy that was there at that time has waned. And it's been difficult. Ultimately, for a treaty to be able to improve the word's shared capability to combat pandemic threats, it needs to be able to hold states to account. They have to comply with it. And that's where the article published in The Lancet comes in. Through understanding what we have frameworks in, for example, tobacco control, and analysing what's worked and what's not worked, it offers 6 policy recommendations that are described by the authors as politically feasible mechanisms that could create compliance pressures to shift state behaviour. Thank you so much for joining us today. I'm really delighted to be here and to moderate what I know will be a stimulating conversation. We've got a brilliant lineup of speakers, and I'll introduce them as we go along. So without further ado, up next talking about the big picture will be Dr. Matthew Kavanagh, Director of Georgetown University's Global Health Policy and Politics Initiative at the O'Neill Institute for National and Global Health Law, and an Assistant Professor of Global Health and Visiting Professor of Law. Matthew, over to you.
Thanks, Jessamy. Thanks, Jessamy, and thank you to the Lancet for getting this article out in a timely moment when we are sitting as the INB is meeting to negotiate the next round of the pandemic treaty. 14 million lives is the number roughly that was taken by COVID-19. And we know that there were a variety of reasons why that total ended up at 14 million and counting. And one of them is that in a pandemic, coordination among states is critical. It's a critical tool. And yet the institutions of global governance didn't work as planned, as we all know. One review, said that it was non-compliance by states with their obligations that contributed to the COVID-19 pandemic becoming a protracted global health emergency. We've identified as we looked through that there was inadequate data sharing, that there was a disregard of temporary recommendations made by the World Health Organization to mitigate disease transmission. We've noted that the imposition of measures that went beyond WHO recommendations was common and problematic. There was a ignoring of requirements that bilateral and multilateral collaboration and aid happen. And there was a disregard of political pledges made about distributing vaccines. All of this led to greater spread of the disease. And so the response from the global community has been IHR reform and a new pandemic accord. The CA plus, we'll refer to it throughout as the treaty or the accord, et cetera, to really specify what are the obligations in international law. But having precise obligations, but no mechanisms to ensure that states actually comply with their obligations will not be nearly as effective. The impact of this treaty will depend in part on how good the compliance is. Some in global health seem like they're content to say that it's okay that we can't possibly have better compliance, that the World Health Organization is too weak, that it lacks enforcement powers, that the international pandemic law overall is too ambitious. We can't secure compliance, but we disagree. We've actually looked in this paper at the history and the research on political science and international relations to show that, in fact, there's a wide variety of compliance mechanisms, and that the vast majority of those compliance mechanisms don't depend on economic sanctions, they don't depend on military intervention, they depend on building the kinds of institutions that are 100% within the grasp of this pandemic treaty. And so part of what we want to say here is that there are opportunities to build in compliance mechanisms that research shows could be effective. In this paper, you'll hear from, and today, you'll hear from us on a variety of fronts. Claire Wenham is going to speak on IR and compliance, and then Larry Helfer is going to come in to talk a little bit about how we characterized the international legal mechanisms that could be in a pandemic treaty. You're going to hear two examples, one from Alan Meleche about how human rights institutions have built up compliance mechanisms, and from Atiya Waris about how international finance and investment law has built up compliance mechanisms. I'll walk through proposals that we put forward in this paper. We make 6 proposals. One on the COP, the Conference of Parties, and what kinds of parameters would make it effective. 2, independent rapporteurs with a clear mandate. 3, a formal dispute mechanism. 4, a structure for civil society reporting and accountability. 5, a platform for assistance requests. And 6, alongside all of that, text that actually builds up trust through trust building activities. We think these 6 measures come out of the research in international relations, and therefore there's an opportunity to bring them in. And with that, I'll turn it back to you, Jessamy. Thank you.
Thanks, Matt. That's a brilliant big picture start and a great introduction. So we're going to turn to Claire. Dr. Claire Wenham is an Associate Professor of Global Health Policy at the London School of Economics and the Director of the MSc in Global Health Policy. She holds a PhD in International Relations, and her research seeks to understand how state and non-state actors prepare for and respond to epidemics, what political challenges there are in the global health architecture, and what the downstream secondary effects are of policies introduced to mitigate epidemics. Claire, you're in a great position to tell us, why do some states comply with international agreements? Why do others not? Do they ever? Because I think some people are feeling pessimistic about it.
Sure, thanks, Jessamy, and thanks, Matt, for your leadership on this paper. What I wanted to talk about is just to kind of take us back to the kind of more theoretical work in international relations, which really talks about why governments or states do anything, right? How do you get governments to comply with international law? Because if you look at more political science and some international relations literature, often there's this conversation around, well, compliance can only happen at the domestic level when states have the monopoly of the use of power, and therefore they can make people do things, make law work, because they can, put some sort of mechanism in place to penalize or to encourage compliance. The use of security services, the use of the police, the use of court systems, and legislative, judicial, executive mechanisms to do so. So there is this, assumption that then at the international level, where those mechanisms, those legislative, judicial, executive mechanisms don't exist, it's this state of anarchy, and governments won't do anything, states won't do anything, because there's no power above to ensure that they do so. But actually, if you look at the theoretical literature in international relations, it gives us 5 reasons why governments might comply with international law. And we're going to quickly run through those, and then I'm going to pass over to Larry, who's going to talk about how this gets operationalized. So the first one is reputation. So we know from international relations that governments want to be seen as a good ally or partner on the international scene. They want to do this either to enhance negotiation power, to be able to maybe take leadership positions in international organizations, to be able to influence the global agenda on a particular issue, and being seen to be compliant with international law is a way of doing it. Other states might want to comply within this idea of reputation because they want donor dollars, right? And they want to be seen to be playing the game of international law, to be able to then be saying, look, this is why you should invest in me or offer overseas development assistance, because I'm a good player. So that's the first one. The second reason governments comply is through reciprocity, right? They want other governments in the world to comply, so they can, for example, get data about surveillance, whatever it might be, And so they play their game. It's a very reciprocal transactional relationship where I'm going to do it, and therefore I expect you to do it. And even if that's not in their immediate interest, we see governments complying with international law for reciprocal reasons. The number 3 is a fear of retaliation. So we know that in some spheres of governance, that different international organizations or other mechanisms have retaliation for a lack of compliance. So this might be through economic sanctions that we can see at the WTO. It might be through military interventions, which we see. And a lesser extent from these kind of really hardcore sanctioning abilities is also a limitation on rewards, right? Whether that be in terms of access to preferential markets or material incentives, which might get taken away if you don't comply. So it's this concern of retaliation. The fourth thing international relation tells us as to why governments comply with international law is around legitimacy and sort of internalization of the global normative landscape. So this can be, for some, it can be about having statehood and being able to sign up to international law if, for example, you're a new or a weak state, and actually having the power to do that and to sit at these global conversations is something that states want to be able to demonstrate they're doing. And similarly, there's a normative importance amongst government officials that they want people to abide by law within their countries. They recognize the value of legislation and legislative compliance. So as an actor themselves being subject to the legislative body, they want to be able to demonstrate they are doing it. And then the fifth and final reason we see in international relations is about the sort of democratic relationship between governments and their populations and their civil society groups. And for example, we see often, we can see civil society groups or population holding a government to account for their interaction with international legal agreements. So for example, we saw this with the Paris Agreement in the Netherlands, where civil society actors took the Dutch government to court for not abiding by what they'd signed up to in international law. So I think where this comes to is there's not one reason that governments may comply with international law, and nor is it a binary, right? I think that's really important. You know, there's a gray area of compliance, and I think we need to think about what is it exactly we're trying to get governments to comply with, and what are the reasons that they might comply more readily with some areas and not with other areas, and then what are the ways that we can think through how to overcome those hurdles. So again, thinking about the problems with compliance that we see and the different ways that we understand that governments operate through looking at international relations. And I'm going to pass over back to Jessamy because we're going to hear about the mechanisms through which we can do this. Thank you.
Thanks so much, Claire. And I really like this term that you use in the paper about the shadow of the future, or future shadow kind of working. You know, this idea that you might not do it now, but you're doing it because in the future you hope that there's going to be something that comes back to you. Next, we're going to hear from Larry. Larry Heffer is an expert in the areas of international law and institutions, international adjudication, dispute settlement, human rights, and international intellectual property law and policy. He is co-director of Duke's Law Centre for International and Comparative Law, and also serves as a permanent visiting professor at the I-Courts Centre of Excellence for International Courts at the University of Copenhagen. I hope I got that all right, Larry. Larry, this paper makes use of a few conceptual frameworks, and you don't know this about me, but I love conceptual frameworks, so I'm really happy you're going to talk about this, basically. Tell us more.
Great, thank you so much, and thanks everyone for attending. So what Claire has done is really beautifully set up the different theories about how one can promote compliance with state obligations using a range of different incentives, positive incentives, negative incentives, incentives below the level of the state, across states, and so forth. But how do we turn these theoretical frameworks into practice? So the specific institutional design choices that states make when they create new international legal obligations and new institutions are really critical here. Those design choices often reflect the type of cooperation problem that states are facing, and they seek to harness some of the compliance pressures or compliance obstacles that Claire was describing. So in the paper, we draw on an existing literature in both domestic administrative agencies as well as in international relations theory to talk about three different mechanisms: police patrols, fire alarms, and community organizers. So these are different ways in which you can harness international institutions so as to incentivize compliance for states. Again, understanding that hard sanctions and punishments are very unlikely across the length and breadth of international law, but particularly in the global health space. So let me briefly review each of these: police patrols, fire alarms, and community organizers, and then say a word about how they interrelate, and then turn things over to Alan, our next speaker. So police patrols are essentially trust-building review mechanisms in which a standing body at the international level systematically monitors compliance to detect violations. This can be done in a number of different ways. It can be done whereby states have to report periodically on particular types of compliance measures and implementation measures they are taking. It can be done more proactively, where a monitoring body reaches out to particular states, identifying a particular emerging problem and says, please tell us what you're doing to address that problem, and the mechanisms that the implementation strategies that you're adopting. So information sharing is really important here. So is trust building. So is creating an understanding and awareness that a state's record vis-a-vis its international obligations is going to be monitored externally outside the state. And so for that reason, although, as we'll discuss, there are a number of different mechanisms in different parts of international law. Police patrols are very, very common. The second kind of mechanism, which goes by the label of fire alarms, essentially delegates the search for violations of international obligations to other actors, who can then, on their own initiative, trigger some sort of alert or warning to flag the violation and hopefully then increase the pressure for compliance. So in terms of who triggers this fire alarm, it could be another state, it could be a civil society organization, or it could be an individual or some combination thereof. Now, one of the nice things about fire alarms in terms of promoting compliance is that they don't rely on the knowledge of an international body that is monitoring perhaps up to nearly 200 states to identify violations. Rather, those individuals who are aware of violations on the ground, individuals or organizations, have the incentive to bring these sorts of complaints to the attention of the international community, and in specific to the body that a treaty creates. So examples include the WTO dispute settlement system, individual complaints to the Inter-American Commission on Human Rights, and others. The third mechanism, the community organizer mechanism, this is, I would say, for the authors of this paper, our conceptual addition to the literature. Police patrols and fire alarms were quite well known. Community organizers at the domestic level address challenges not by patrolling for problems or waiting for individuals to raise an alarm, but rather by creating venues or platforms to calling together the different members of the community to identify a particular problem and then resolve it through, in particular, sharing of resources and information. So these mechanisms do, particularly at the international level, identify compliance gaps, those things that might otherwise be hidden from the police patrol or fire alarm mechanisms, and that help to close those gaps by facilitating financial, technical, or other forms of assistance. This community organizer model builds on the managerial compliance literature in international relations, but it goes further by creating a deeper web of relationships. So the final thing I wanted to say before turning things over to Bethany and then to Alan is that it is often the combination of these different mechanisms that can be especially impactful. So it's not as if you have to choose 1, 2, or 3. In fact, some of the different international issue areas that we discuss in the paper combine at least 2 and sometimes all 3 of these mechanisms in order to harness and incentivize the pressures for compliance, both positive and negative, from a variety of different actors. And so with that, I think it would be helpful to turn things over to our next speaker so that you can get a sense of how that functions within the area of human rights law. Thanks.
Thanks so much, Larry. That's exactly right. We're going to dig a bit deeper. In the paper, there are 5 different areas that it draws from, which is human rights, finance and investment, international trade law, environment and tobacco. But for the sake of time, we're just going to look at human rights and finance and investment. So first, Alan Melechi will talk about human rights. He's the executive director of Kenya Legal and Ethical Issues Network on HIV and AIDS. He sits and co-chairs the UN AIDS Human Rights Reference Group and is a member of the International Advisory Board for the Global Health Center. Alan is a practicing lawyer and human rights activist with over 15 years of experience in law, ethics, governance, policy, health, and rights. Alan, human rights institutions are massively complex, but as Larry said, you've all kind of described these 3 ways to achieve compliance. Maybe you could just tell us a little bit more about, in more detail, how that plays out in human rights and illustrate it for us.
Thank you. And just to build on what my colleagues have said is to say that any international mechanism is complemented by various domestic institutions that protect human rights. And the domestic institutions that protect human rights would normally include constitutional courts for countries that have them, Supreme Courts or High Courts that would normally adjudicate the violations of rights protected within domestic treaties that countries have ratified within constitutions, within statutes, or also in the context of national and national human rights institutions and other independent bodies. So I think the starting point we have to keep in mind is that a treaty has to be domesticated, or a country has to be bound by it for us to be able to trigger some of these mechanisms at a national and a regional level, as mechanisms such as the police patrol or mechanisms that revolve around the fire alarm methods would largely have to be complemented by the domestication of the particular instrument. And so in our experience from other treaties, we have seen the use of offices such as the Office of the Ombudsperson or Office of the Health Ombudsperson in South Africa or in other countries, which would investigate complaints and monitor adherence by public and private actors. So assuming that this particular treaty is adopted and countries domesticate it, that becomes one of the ways in which a monitoring role can be played to see how do we give life to this particular treaty. Of course, the most other common way would be for people to actually go to court and litigate and say certain provisions of the treaty are not being complied with, or that their governments have a duty to fulfill or put frameworks into place that would ensure compliance with this particular treaty. Then consequently, there's a whole conversation around what rights or what obligations arise from this treaty that are already mirrored within national laws, national statutes, existing constitutions, which people can anchor on in addition to the particular treaty to be able to take some of those aspects forward. And so it's important for us to appreciate that for us to be able to take this compliance aspect to a level where it now benefits, for lack of a better word, the person on the ground, there needs to be some level of knowledge, appreciation, and ability of the institutions at the regional level, in the case of regional human rights courts, as we do have them in Africa and in Latin America. How do we ensure that such bodies, such courts are aware of their obligations around bringing this treaty to life? How do we ensure we work closely with community groups or those who may be affected by one way or another with issues coming through pandemics, to be able to engage these mechanisms, to be able to engage affected communities to pick up the cases and work with different experts, including special rapporteurs who would do special missions, and in a combined way and in a combined effort to be able to get the result that we want, which is accountability of countries or governments towards what they have committed to in some of these treaties. I'll turn it back to you for the next conversation. Thank you.
Thanks, Alan. That's really helpful. I think now we're going to have a look at finance and investment. But actually, before we do that, I think we were going to ask Larry whether he wanted to add anything from your perspective, obviously coming less from the kind of domestic side, but more from the Geneva-based Human Rights Council perspective. Would you like to kind of elaborate on things or give us some illustrations?
Just say a word or two. I think Alan did an excellent job on that. The only thing that I would add is just to reemphasize again the mix of the different mechanisms. And you can see that very much in the UN human rights system. You have both political bodies and bodies of independent experts. And we have a couple here on this panel. And they also, the functions that they engage in include both really all of the different mechanisms. And it can be quite challenging, I would simply say, to wear a hat where you are both engaging in, or multiple hats, where you're involved in police patrols and reviewing fire alarm claims, and also attempting to assist states with their compliance in a kind of community organizer capacity. The last thing I'll say is simply that it's the connection not only across those functions at the international level, but even more importantly, how those functions can often help to mobilize civil society at the domestic level that really helps to determine whether international commitments are respected. Because no matter how much pressure you bring state to state, the vast majority of international issues also require advocacy from the grassroots up. And so connecting those two is really important. So Alan's insights were really excellent in that regard. Thanks.
Thanks, Larry. So Dr. Atiya Waris is from the University of Nairobi and is the only professor of fiscal law and policy in Eastern and Central Africa. She holds a PhD in law and is a specialist in fiscal law, policy and development. She also serves as the UN independent expert on foreign debt, other international financial obligations and human rights, and is appointed by the UN Human Rights Council. Atiya, you work in the deep intricacies of international finance and investment. And in the paper, you allude to some of the ways that they've made countries comply to these financial sort of rules and regulations. Maybe you could tell us more about that, but also, I guess what I'm really interested in is why, and you allude to this in the paper, why they're more relevant than global health. And, you know, global health is kind of deprioritized often. Over to you.
Good afternoon. Yeah, so you pointed out exactly what part of the paper I'm inputted into. That's absolutely fine, Jasimi. Good afternoon, everybody. Even though we've written it out the way we have in the paper, I'm going to try and sort of extract, but also sort of restructure and analyze it from the way I see it in a bigger picture. So when it comes to tax and trade and investment treaties, I find that when I compare them with human rights treaties, which have already been discussed, their enforcement is much more effective. It's much stronger. There's a bigger effect, and there do result in changes in the grassroots, in countries and in regions sometimes. But it's a double-edged sword, because its very effectiveness means that it's also a tool that can be extremely destructive. So if I were to talk to the people who are working on developing the treaty, then this is something to keep in mind. You have to nuance it very carefully, and you have to understand also when to stop it, when to bring it into place, kinds of timelines, so very practical. But let's look at what does exist. So we have treaties that are bilateral. For example, we have bilateral tax treaties. And very often they have model conventions on model clauses on dispute resolution, often arbitration, always confidential. Usually they choose an arbitrator or arbitrators. They fix it in a particular location. It doesn't engage with the judiciary or the domestic system of a country. This in itself causes a lot of challenges for developing countries because it's extremely expensive. And frankly, it's often in the global north. So it is an added expenditure for a developing country that's faced with it. But in the pandemic treaty, it may be a slightly different environment, because I think it may be developed countries who would have to come into the forefront in actually implementing things and may be held up to account. So I think the dynamics in health may be a little bit different from what happens in tax in that case. But that's the bilateral space. When it comes to the multilateral space, then that has developed a lot less slowly. So this is more in terms of what we call blacklists, gray lists, or white lists. So either regional bodies, sometimes membership-based global bodies or institutions like the FATF, the OECD, the European Union, will release a list of countries they feel have good laws or regulations under taxation or bad laws or regulations under taxation. Of course, there is no international body that has done that yet. So it tends to be very membership-based. So this is again a problem which would not be faced by the WHO because it's a global entity. So when you have entities like the European Union or the OECD making lists like this, then there's always allegations of if there's a different set of standards for non-member states versus member states. So these are things that we've had to grapple with. But in those lists, some of the bigger problems facing many countries is when you get on the list, how quickly can you get off the list? At what point in time will they have been considered to be compliant? What level of granular change or data, legislation or policy or regulation needs to be put in place to shift you from the, black to gray to white? Now, I'm using black to gray to white, but the problem is that even the language of black, gray, and white is problematic because of how it is very often developing countries on the blacklist and Western European on the white lists. So we would have to use maybe a traffic light situation rather than the language of black, white. I mean, these are things we've learned on in our spaces. But in addition to all of that, one of the biggest problems that we are facing in all of these different mechanisms is issues around hidden sanctions. So if, for example, somebody's put on one of these lists, then very often a regional body will turn around and say, well, you know, because you're on this list, we're not going to give you 100% of your remittances. We will give you 75% of your remittances. I mean, these are real life things taking place even as we speak. So 25% of financing is then withheld on each transaction, both private and public transactions. So we would not necessarily hear about it, but it could be an insurance company's insurance claims not being paid off on reinsurance, or it could be a banker's financing. You will receive your full transfer, but the bank itself may not receive its full transfer. So these nuances are not always so overt. Very often countries are not aware of it until after they are put on those lists. So this is why there is a lot of debate and discussion about what gets you on the list, what gets you off the list, how quickly can you get off the list. And one of the problems we had during COVID was normally you would have in the assessors going in physically to check if a country had changed its legislation and then move it to the next level. But during COVID, that couldn't take place. So desk reviews were taking place. And unfortunately, those are not as thorough. So countries, again, got stuck on lists and COVID wasn't really reflected on. And then the economy takes a hit. Because there are finances that don't shift back and forth, The moment you put somebody on a sanctions list of any kind, there are economic repercussions. And so even while we are talking about global health here, we have to be aware that putting any kind of enforcement measures can have an effect on the ability of an economy to continue to exist, stay stable, and then grow in the future. The last thing I want to talk about is the issue around power politics, which I've mentioned a little bit before, but that is probably going to be one of the biggest impediments on getting clauses like this in, because traditionally it has been directed towards southern countries. Unilateral sanctions tend to be on southern countries. Coercive measures tend to be directed towards southern nations. And so this kind of a clause in a pandemics treaty will be very holistic for health based on our COVID experience. And I think that that is probably what's going to cause a lot of tension in the discussions. This is me speculating, of course. I am in full agreement with the other speakers, with my colleagues who've talked about the fact that it's a combination of them that work. And I would just like to add, because I am the current mandate holder for debt and I am within special procedures, one of the things that works really well is when you've had a universal peer mechanism taking place, and then I do a country visit, and then we do letters. So it's a combination that always works. I think what would be very exciting in this entire conversation is seeing what combination will be seen to be very effective within the WHO and within health. And I would like to encourage cross-pollination across existing systems. So, I mean, it's great to create their own, and I think it is important to have it, but I think it's very important that the world doesn't get further siloed. And I would hope that they would look towards the other compliance mechanisms already existing in human rights, as well as in these other spaces which we've all discussed, and then borrow and or utilize what already exists so that there isn't a duplication. Thank you. Back to you, Chair.
Thanks so much, Tia. That was a brilliant summary. And I suppose thinking about, those 5 reasons that Claire was talking about why countries comply, obviously many more of them are linked into financial investment things, the legalized agreements and the retaliation and all that kind of stuff. Very interesting. So we've come to the end of our sort of main presentations. We're going to go back to Matt for a sort of brief overview of some of the other areas. But while we do that, please get your thinking caps on and start putting in some questions into the Q&A, because we've got a long time for a discussion afterwards, and it would be great to have some stimulating, interesting questions and a rich discussion. I've obviously got some questions that I'll ask you anyway, but Matt, maybe you can give us a quick wrap up and also take us through those policy recommendations.
Great. So thanks to everybody. And I think in the paper, we explore a variety of different mechanisms. We look at beyond what Alan and Atiya have spoken to. We also look at international trade law. And there, I think the key piece that comes out is a dispute settlement mechanism, right? That's formal and engaged. And that's been hugely effective when it comes to what's happening in trade. And I think the key piece we take away from that is that it's not actually sanctions that end up being the most important element of that. It's actually the process of having a dispute settlement mechanism so that countries can raise specific things, because as we document in the paper, the vast majority of disputes get settled way before it gets toward anything like sanctions. And so it's actually a diplomatic tool that enables countries and states to pull out a very specific issue and bring it to the fore. Second is environmental law. There are a wide variety of stuff with credit to our colleagues who helped write that. One of the key pieces I would pull out from that is that there are effective platforms for countries to identify capacity gaps and obligations from other member states to respond. And that mechanism has been effective in environmental law. That's worth looking at as another mechanism. And then in tobacco, we've learned a lot about the use of a conference of parties. We've seen what has worked, but we've also seen what hasn't worked. And so we engage in that in the paper. Having looked at all of those different pieces, Excuse me. Having looked at all those pieces, let me just share my screen for a moment where you can see what the different kind of recommendations we've made out of this are. And what we overall come to is a set of 6 recommendations about which kinds of mechanisms we think you could learn from, both kind of 2 sides of it. One, what are the mechanisms that have been effective in other parts of international law that could come in to the pandemic treaty? And second, why would we need a mix of those to trigger the kinds of pressures that Claire was talking about, the kinds of compliance pressures? And in fact, we talk about a matrix of compliance mechanisms that together could impact. So I'll run through them briefly. The first is a conference of parties. This has already been proposed. And so in the paper, we talk a little bit about what does it need to be effective? And the elements that we see are: 1, the power to make rules; 2, the power to provide direction about what implementation actually should look like; and to order investigations. To be effective, this mechanism needs to have sufficient funding so that it has a secretariat that works, and there has to be equitable participation of all member states. And one really key piece is that civil society representation needs to be explicitly spelled out here. If you do those things, we think that triggers the kinds of IR researched pressures that include an opportunity for positive reputation, right? As well as negative reputation. States, as you heard from Claire, have an interest in that. The opportunity for peer pressure within a COP is not something that will just happen on its own. But if we do institutional design in an intentional way to maximize the opportunity for peer pressure, it can be hugely effective at pushing states to respond and to comply. And states have this desire for reciprocity. And so a COP can magnify that if done well. If done not so well, what we've seen also is that it can have very little impact. And so the question of whether this will be an effective mechanism is about the institutional design. Second, we propose independent rapporteurs with an investigatory mission. I say this, with Atiya Waris, who is the UN independent expert on debt and finance, on the call. And so, I say this with humility for what she knows, and I do not. But if we draw on this experience of the human rights infrastructure, what we see is that rapporteurs are able to undertake missions. They explore key issues when it comes to implementation, issue reports on areas of concern, and in addition to that kind of much more police patrol mechanism, they also accept and review complaints, including from individuals, and that can create a different kind of fire alarm pressure. This is not the same as a proposed panel of experts that's been already proposed. This is a different kind of effort. It's something with a mission, it's something with some infrastructure to it. And if done well, what we've seen in the human rights area is that it can create pressures for both positive and negative pressures, but also it can trigger those domestic politics that we know are at the heart of what works in compliance. Third, the domestic settlement, dispute settlement mechanism. We think there needs to be a formal dispute settlement mechanism that gives individual countries standing and an opportunity for what we call soft retaliation. States should be able to initiate a fire alarm type mechanism by filing a dispute with the body that's not just about the interpretation of the agreement, but that's about how states are implementing it, the behavior of states. And this goes beyond what is currently in the text, which says use diplomatic channels to resolve disputes. We are saying that what we've seen from international law so far is that a formal dispute mechanism within the infrastructure of the agreement can be hugely important. Drawing on lessons from international trade, what we see is that the mechanism that starts with formal consultations observed by all parties, that's what triggers pressure. And in fact, then countries are worried about their reputation and they do respond before we ever get to the area of pressures. And then we think that it's the platform of required diplomacy that's what this mechanism can do. Without it, dispute settlements, disputes just kind of end up in Twitter sphere, right? And what we've seen is that when states have raised these issues, whether it's border or whether it's vaccine or whether it's a wide variety of information sharing, that in COVID, it didn't work to just hope that the world would comply with the norms. Instead, creating a dispute settlement mechanism could change those dynamics. We know that economic and military sanctions, these are not going to happen. But there are softer forms of retaliation, right? Which are withdrawal of benefits from the treaty, right? Withdrawal of cooperation between states. These are kind of mechanisms that are not hard consequences, but they do trigger the kinds of pressures that were talked about. Finally, we've got a number 4, formal structure for civil society reporting and accountability. We have learned from both the human rights and the environmental regimes that a formal structure for academic and civil society shadow reporting can be hugely important. That could be to the COP, and it could make the COP something that's effective, right? This is not observers. This is a formal structure for reporting, right? And it can be the kind of fire alarm that Larry was talking about at the beginning. It can trigger the kind of positive and negative reputational pressures that can make states act, as well as triggering domestic politics that we know are central to why states comply from the research. Number 5, a platform for assistance and resource requests. Again, this is drawing on experience, especially from the environmental world, in which the treaty could explicitly provide a platform for countries that intend to comply with their obligations, but they lack the capacity to do so. In that case, they can formally request assistance. That could be technical, that could be financial, but the idea is that rather than hoping that the Global Fund over here, or the Pandemic Fund over here, or the WHO over here will hopefully fill those for compliance, we actually put this into a language of obligation, into a language of international law. And that has proven to be really effective. And so it creates the kinds of pressures in which reciprocity is on the table. And finally, 6, formal and trust building opportunities. Mentioned in the treaty several times are questions of joint activities and preparedness activities. These are really important. But what we see from the international relations literature is that trust building activities that develop trust, but also socialize compliance, those really matter. And so rather than being nice to haves, they could require that a set of joint activities and a set of meetings of focal points are something that's required, because we've seen in international relations that that's what can trigger the kind of positive reputation, but also the kind of pressures for reciprocity. One final note before I close, which is just that we also see here an issue of money, right? When the World Health Organization declares a public health emergency, it should automatically and immediately trigger a release of pooled funding. One of the things that IR literature shows us is that actually sometimes states comply for very material reasons, and there's an opportunity to bring those material reasons out. Right now, the Pandemic Fund deals only with preparedness, and the Global Fund's mission when it comes to pandemic response is really unclear. This has to be addressed, and it's not just an issue of ensuring that there's funding available, which is necessary to respond to a pandemic, but it's also an issue of compliance. Even when all of that funding is insufficient, the fact that it's tied to accountability within the mechanisms of an international agreement, that in and of itself could have impact, and that's why we propose that it be done as such. I'll turn it back to you, Jessamy, and those are our 6 proposals. We hope people will read them, take them seriously, and hopefully will make their way to the INB for consideration among the negotiators. Thanks very much.
Very good, Matt. Yes, I think they will. Now, I just want to move quickly on to some questions. We've got some very interesting questions, some of them challenging. So I'm going to start with the most one, which just starts with, I partly disagree. So I think that's where we should start, basically. Gianluca Berkey, I hope I pronounced your name wrong. He says, thank you for an excellent panel. I look forward to reading the article. However, I partly disagree with Matthew's starting assumption that states have massively breached their international obligations during COVID-19. They may have breached policy commitments and expectations and behaved immorally, but legally speaking, international law is very forgiving at times of emergencies, e.g. human rights, trade, and even the IHR. Not following a WHO recommendation is not a breach of obligation. In my view, the problem is different, i.e. the absence of dedicated international rules specifically addressing health protection and coordinating with other legal and policy regimes, with the partial exception of the IHR. That is what the pandemic treaty should be doing, but there's no reason for much optimism given how the negotiations are going. So I wondered whether you might just sort of respond to that, Matt, and it sort of feeds into my question also about how optimistic people are feeling in general. So over to you.
Happy to, and I think Claire probably has some thoughts on this as well. I think what we saw during COVID was absolutely, and I guess I would push on Gianluca with deep respect as somebody who knows this area very, very well. I think there are a wide variety of areas where more specificity is good. So I think, ensuring that this pandemic treaty comes out with precise agreements about what states will do in the future, that in and of itself is an incredibly important task. And so there's no conversation here that suggests that is not important, right? The core question becomes then, if we win really bold commitments, which I agree, there's reason for pessimism, but I think there's also some reason for optimism. Regardless of how bold it comes out as, it will only be as effective as the compliance that goes along with it. And in fact, the more we increase the ambition of the treaty, the more the compliance pieces become important. And so what we're arguing here is that actually during international crises, there are a wide variety of international agreements that should hold forth. I'll defer to Larry on the international law, interpretation thereof, and to Atiya and to Alan, our lawyers, all on the call. But what is certainly true is that we saw states making commitments and then violating them. Whether that was, for example, implementing trade and travel barriers that actually were not based in evidence, in contravention of what the World Health Organization was requiring. And in fact, the IHRs, as Gianluca knows, but far better than I do, are binding international law, although certainly true that the recommendations are recommendations. In so doing, though, states very clearly violated the intent of these agreements, which in fact the core of the IHR is to reduce trade and travel barriers in order to ensure that the impact of pandemics is less. And so the fact that we saw countries, for example, banning travel from South Africa when it was incredibly irrational to do so, right? That in and of itself was hugely impactful on South Africa's economy and had a huge negative impact on the incentives that we want to be driving for countries to actually report when viruses break out. And instead what we saw is countries banning violations, which only encourages countries to not report when there are outbreaks. And so that's the kind of non-compliance that we need to be talking about, as well as, of course, the vaccine non-compliance, et cetera, all of which was non-compliance with a variety of different pieces, some of which were technically legal and some of which were political promises that were made. But if the ambition of the treaty is to include those things, then we need the kind of compliance mechanisms that could do so. And our argument is essentially that that's possible. And we really do think so.
Thanks, Matt. I wonder if I could open that up to the rest of the panel to build off that conversation or to respond in any other way, the lawyers on the panel, or Claire, or anybody. Anyone want to say anything about that?
So maybe I'll just say a word about, because embedded in that question, and I'm glad that we started with that, because obviously you want to start with the most skeptical perspective.
Exactly.
And I would say 2 points very quickly. First, many areas of international law contain rules governing emergency situations, derogations in the human rights context, suspension of obligations in the WTO context, but these are quite carefully managed and limited. So it's true that international law can be forgiving in times of emergencies, but it's a question of how the system is designed. And the way I see this current initiative, at least its aspiration, is in some way to both narrow when emergencies occur through advanced preparedness, and then also provide more specificity of which rules govern during emergencies when they arise. So that's very much what international law will often do. It will provide a safeguard or a safety valve for noncompliance during exceptional situations, but it has to be measured and guarded. The other thing that I think is worth keeping in mind is the line between formally binding norms under international law and non-binding or soft law under international law is rather thin, in the sense that sometimes you can have binding obligations that are extremely vague and general, and then soft law statements, whether in declarations, guiding principles, best practices, that are extremely precise and particular. And the latter, even though formally non-binding, can actually have more of an effect. So part of the trade-off here, yes, indeed, is to try to come up with more robust international rules that are formally binding. But I put less weight in that than I do in the ways in which we can actually channel state incentives moving forward. That's the bigger challenge as I see it. Thanks.
Thanks, Larry. Others?
Well, from a
Yeah.
financial perspective, I'm going to jump in.
Good.
One of the things that I noticed with another piece of research that I did, which was published in the African Review, where I looked at emergency fund pots in national budgets on the African continent. One of the things that we discovered in that paper was, well, I did it by myself actually, but one of the things I discovered was that we couldn't track and trace where emergency funding had been going in the past. And in several countries across the African continent, we didn't even know where the emergency funding was at that point in time. So COVID response rates even were like, they took like a massive step backwards, because it is internationally agreed that budget lines will include a budget on emergency funding, just like you have national food stores, for example, in case of crisis. And this particular crisis not only tapped into the emergency funding on budgets, but because of the crisis in movement, also tapped into the need for food security in countries. So even food stores now had a serious question mark. Domestic value chains were starting to pop up as well. And when I hear what Gianluca is saying, and yes, there is a softer element for issues in an emergency, but I think the question then is, how soft should they be? And what should we be putting in place? So this is the granular issues that in finance and investment law and tax law that we have been grappling with, because when it is too soft, then people take advantage, or countries or states take advantage of it. But when Matthew was talking, it triggered me into, well, what about sanctioning those that work too quickly to have some kind of a clause being put on a country? And that is the problem we've had with the regional blocks or the political or economic blocks in how they mete out some of these police patrols, is they move too quickly, similar to maybe what was happening in South Africa, or they will do something but not reflect in a certain way. And that is why it is so important to have this really well thought out. I would like to answer two of the questions. I don't know if you'd like me to do it now or later.
Yeah, if you've got a passion for two questions, go for it.
Yes, sorry. So Ali Riza Vasi, I hope I pronounced his name properly, talks about the alternative power blocks like the BRICS, which may not necessarily perceive an additional interest in compliance. Well, here, this is an update a little bit on a parallel, but there has been a global push at the UN General Assembly, and there is a resolution currently pending, which was supposed to be discussed in the next session that's about to start, on the creation of a global tax body. And part of the reason there's this push for a global approach to things is because of this very problem of bilateral and selective multilateral approaches, where there isn't a global regional space to deal with it. And a lot of the fiscal implications that we're talking about, which would come out at a certain point in the pandemic treaty, I think should also be tied in with that particular space. So BRICS are behind it, the African countries are behind it, ASEAN are behind it, as well as the Pacific and Caribbean states. So it has a lot of positive push behind it. It could be a real game changer in the long term. The second thing I wanted to respond to was Matt Meyer's concrete examples on compliance tools. So there's an entity called the Financial Action Task Force, the FATF, and we mentioned it a little bit in the paper. And basically what they did was create the black, the gray, and the white lists. And they have a series of indicators. They do studies, they send assessors and investigators to countries, but they use like a peer review mechanism. So it's one country's tax assessors going into another country, for example, to check if the systems have been made more robust. The peer system seems to work quite well, I think, in some cases, and in other cases not so well, but it is a concrete example of the police patrol rolling itself out, at least in my spaces. The second concrete example, which I think is very useful, is as a rapporteur, and I don't know if Alan, I'm taking a little bit from you here, but I, for example, go into a country And very often I go into a country during the year, but my report is presented in March of the following year to the Human Rights Council. And what I find very interesting is that if I'll do the visit in August, the country gets the report by December. By the time I'm making my presentation in March at the Human Rights Council, very often that country is already saying, well, oh yes, point 1 that you mentioned and point 5 that you mentioned, we've already amended the laws. So these are positive examples and very concrete that take place, but often are overlooked. Thank you.
Thank you. And thanks so much for highlighting those 2 questions. Alan, I can see you've got your hand up, and then other
Yes.
panelists, if they also want to jump in on either of those 2 questions,
Sure,
please
just
do.
want to pick up from where Atia left and say that I have used a lot of the special rapporteur mechanisms, particularly for our tuberculosis work. First of all, through filing complaints of violations where the state was jailing people who had not been adhering to their TB treatment, and consequently using some of the reports of the special rapporteur as evidence before our courts for purposes of litigation to sort of demonstrate to the court the kind of standards and expectations where the government has not been complying. So at least for me, as a person who litigates a lot, the special rapporteur reports both at an international level, but also for regional mechanisms that have got special rapporteurs on aspects, say, of women's rights, issues of prisons. Those become interesting tools that one can be able to utilize to be able to enforce or to use for advocacy purposes, because I've also seen the special rapporteur's reports used for advocacy around issues of access to medicine, issues around strips flexibilities. And so it's possible to use it for both mechanisms, both the formal legal process, but most importantly as something that you use to light fire under the feet of government around negative reports that may have come out. So let me just contribute to that. And I know there are so many questions, but let me leave room to the other panelists. And we want to try and cover as many questions as possible. Over.
Thanks, Alan. That's a great addition. Other panelists on those 2 questions, one of them was about concrete examples and one was about sort of piggybacking on other types of mechanisms.
I can jump in for
Claire.
one quick question, Jessamy. I mean, I read that last question slightly differently. Was it the last question? The one about the kind of non-conforming states and kind of different types of states in IR. And, you know, I think whilst what we've done in this paper is thinking about kind of why do most states comply with most international law most of the time, you know, it's equally important to understand why they don't. And are there reasons for that? And, you know, in international relations, we talk about, you know, pariah states, rogue states, countries that want to use international processes to destabilize, right? And for the purpose of destabilizing. And I think, you know, we can talk about that and talk about how non-routine, congruent behavior in international relations occurs. But actually, I think that's the minority, right? I think there's only a handful of states that we're actually talking about who are in that category and who would use something like pandemic treaty processes, negotiations, and compliance for that purpose. I think from my assessment of it is, you know, most of the parts of the pandemic treaty will be complied with to the extent that governments can, right? And the reason they're not going to be compliant is, as one of the other questions mentioned, right, financial, right? Like, have governments got the capacity to implement all the things that are going to be part of this treaty? And, you know, the latest Bureau drafts of it, it's extensive and long, right? And where's that money going to come from? And where's the support going to come from? And we know that there are efforts both through the multilateral space, through overseas, through development banks, through bilateral assistance that are trying to support. But that historically, you know, looking at how the JEE and the IHR work together hasn't been sufficient, right? So where's this increased volume of money going to come from to meet the increased burden on health systems that's going to, or on governments to improve their health systems, going to come from? That to me is going to be one of the big reasons. The other one is going to be more, you know, states will comply with what they can. And then what we're trying to get at in this paper isn't necessarily that, though. It's when governments can and choose not to, right? And that won't be system-wide, right? It won't be that a government just doesn't comply with any of it. It's more likely that the bits that get more political, particularly at a time of crisis, when everything's up in the air, which is exactly what it's needed for, right? That's exactly what happens during epidemics and pandemics. How do we get the kind of normative change of thinking to take part? And I think that's really kind of bigger question. I think, you know, the kind of outliers of the rogue states are really quite few and far between.
Thanks, Claire. Really helpful, and feeds into the paper. And you lay out those 5 reasons why states don't comply. And your first one is about limited resources. So they can't, even if they wanted to. Anybody else want to jump in on those 2 questions? Otherwise, I feel like we should go to a question about vaccine equity, because it would be wrong not to mention that, I think, in this context. Saeed Hassan Khalid, she says, thank you for your time, or he says, thank you for your time, but an insightful discussion. How does the proposed mechanism, oh, it's suddenly gone somewhere else. Here it is. How does your proposed mechanism in the pandemic treaty deal with the vaccine politics by the powerful countries towards the less developed nations, and any possible ways out? I think we need to cover this in some format probably today. So we should probably do so now. Who might be able to kick us off in answering that?
Let me start and try to give some senses. I mean, this is one of the hardest nuts that the pandemic treaty is going to have to figure out, right? I mean, the politics of this are very clear, that what the countries of the global north are looking for greater specificity of reporting and data sharing and information sharing so that they can take action during a pandemic. And many countries of the global south have been focused on the sharing of technologies and the sharing of access to doses in a pandemic when it comes to response. And this is, in fact, one of the collisions that's going on right now at the IMB, at the variety of mechanisms that are happening. We're going to be on the 20th of September, the UN General Assembly is having a high-level meeting on pandemics, and this has been one of the most contentious questions when it comes to this. My hope is that countries will be able to ensure that in the pandemic treaty, there's some level of specificity about the sharing of technologies and the sharing of benefits and the sharing of doses. My own particular view on this is that we should focus far more on the sharing of technology than on the sharing of doses, because we know that in an emergency, countries act self-interestedly. There are actually a lot of political science literature that suggests that there is unlikely that a country is going to say, sure, why don't we send doses to X country because they need it more than we do, rather than vaccinating all of our people. So we know that there's going to be political pressures to vaccinate all people, but the opportunity for the pandemic treaty, I think, is to say, while doing so, let's ensure that we share the technology in the middle of a crisis so that everybody can make their own doses, and so that we actually alleviate the pressures and we don't put ourselves in a situation of limited doses that then are going to be unequitably shared. But assuming that happens, right, which I think is a big assumption and a hope for the pandemic treaty. In fact, I think a requirement for the pandemic treaty to have legitimacy in both the global north and the global south. If that were to happen, then the question is, how do we ensure compliance with that? And our argument here throughout is not that there is some magical compliance mechanism that will simply work, right? We're not in a world of sanctions. There will be no invading armies. There will be none of those kind of pieces there will be no peacekeepers to capture doses. None of that is going to happen. And so some want to throw their hands up and say there's nothing we can do. But I think ensuring that, for example, there's a special rapporteur who's able to actually investigate inequitable distribution is a key helpful thing. Ensuring that countries actually have to come to a forum, an international forum that's formal, and explain their behavior vis-a-vis this is really important. One of the things that happened during COVID-19 is that the countries that were capturing all the supplies at no point had to come before an international forum and explain why they were capturing all the supplies, despite their political pledges to do the opposite. And so what we're saying is that international law is actually largely about interaction, and compliance comes primarily from that international political interaction. And so let's create mechanisms where countries are required to come and interact with each other, to explain their behavior, and where bad behavior is pointed out, not just in the media and not just on Twitter, but instead in an international forum where countries are required to respond. And if that happens, we think that will increase the pressure on countries to comply in really helpful and powerful ways.
Thanks. Kind of that sort of reputation and accountability and sort of showing people up almost. Adia, you've got your hand up. It would be great to go to you next.
Yes, just to add that in addition to the sharing of technology, there also has to be sharing of information on the financing of the development of these things. We had pandemic bonds that were released, but when I spoke with a lot of developing country governments that had researchers who could have worked on vaccines, alternative vaccines, they were unaware of the access to financing. And when you look at the access to financing specifically, there have been cases where big pharma were aware of it because their governments were in deep connections with international financial institutions, and developing countries that did not have big pharma didn't have that same leg up to be able to access vaccine bonds. So I think access to information and specifically access to financing is very important.
Larry, Alan, Claire, do you want to come in on vaccines at all? Thank you for that, Adia. Or should we move on to another question? I think we're going to move on to another question. Someone here has said that Benjamin Mayer has asked a good question. And so because two people have said it, I feel like we should definitely respond to it. He says, thank you for this timely conversation on the complementarity of accountability mechanisms to facilitate the implementation of global health law. In considering these accountability mechanisms, it would be helpful to hear more about the specific data indicators that accountability mechanisms would review to assess compliance violation. How would we know if a state is failing to meet its obligations? There are a wide range of mechanisms to assess implementation, and your article provides a helpful survey across sectors, but it remains unclear how these mechanisms would identify state implementation over time or weaknesses in meeting expectations under international law. Larry, can I go to you first of all?
Yes. So Ben, thanks for the question. It's a very good one. And I think it just goes more generally to the kind of pessimist-optimist themes that we're seeing in the comments, and that I think, to be fair, all of the co-authors share. There's a glass half full, glass half empty kind of situation. I'm not in a position to answer specifically regarding indicators in the global health space, but I think you are already familiar, Ben, and others I'm sure are too, with how human rights bodies such as the Committee on Economic, Social, and Cultural Rights has moved much more specifically to request, it's true for other human rights mechanisms as well, disaggregated data, very detailed data on various kinds of compliance mechanisms, has initiated follow-up procedures to implementation, has attempted to engage with civil society. So what I don't know, and maybe one of the other panelists here can speak to, is do we even know what the relevant data and indicators would be that we would want to look for? Once we do, or if we already do, then I think we have a baseline metric against which to measure what states are doing. If I understand Matt's previous comments correctly, I think one of the concerns is that there's a little bit of smoke and mirrors going on, where there's a kind of general high-level commitment to share and cooperate by states, some states in the global north, particularly with respect to vaccines and other health resources. And then there really isn't follow-up, and there's no mechanism to test that. So part of it is just having a mechanism in place with, one would hope, independent experts and the ability of non-state actors to be able to pull the fire alarm would help to keep the pressure on states toward fulfilling the pledges that they make, even if they are formally non-binding, and they may well become more specific and binding in the pandemic treaty. So I think that's how I would frame the question more generally. And I do think it's iterative. It does arise over time. It is not something we will get right away. So it isn't perfect when we're facing the next crisis. What we need to try to do is build in the capacity now before the next pandemic hits, because obviously that kind of response in the moment is going to be fraught and sometimes problematic. I'll stop there.
Thanks, Larry. And Claire, your expertise here would be very welcome also. You've got your hand up, so that's perfect.
Yeah, sure. I mean, look, I'm no lawyer, so I defer to Larry and Ben. He's asked a question about kind of the obligations and how that works. But we have a whole bunch of different indicators that are in this space that are currently being used, right? Whether that be JEE tools, which were updated last year, whether that be the proposed Universal Health Periodic Review, which is in pilot stage at the moment, whether that be the whole host of non-WHO metrics, the Global Health Security Index, for example. But I think that what's come out of the COVID pandemic, right, is that we've been measuring partly the wrong stuff, right? And actually, when it comes to thinking about pandemic preparedness and actually how ready we are to deal with it, we've been far too focused on the technical public health stuff and haven't considered at all the broader governance issues, broader political issues, and socioeconomic issues. And that, to me, is in part because of the kind of, dominant framework of health security being a Western-centric thing. And it was basically, a policy agenda set up to get surveillance data from lower middle-income countries to protect Western states, right? And that's effectively what it was. And that's why we have been completely focused on surveillance. And I'm not saying we shouldn't get surveillance data, but that's only part of a much broader picture of stuff that we need to be thinking about and collecting data on. The problem is how expensive that would be and who has the mandate to do it, because we have a divided system where WHO is only able to, realistically going to be able to collect public health data. And yet this treaty is going to sit within WHO. And so therefore it's not going to have the mandate or the financial resource to collect all that information. And then what do you do with that information? If you're using state sources of data, how reliable are they? That's going to be completely variable depending on where that data is coming from and how trustworthy it is. So you need a whole new level of, considerations of that data. So, I completely take your point, but it's such a big question that's never going to be answered by this pandemic treaty, which is a shame, because this pandemic treaty was supposed to, go beyond the technical and have a much more political approach to it. But that doesn't seem to be how it's rolling out just yet.
Thanks, Claire. Do any other panel members want to come in on that question? If not, then I think we've probably got time for perhaps one more question before we wrap up. There's some really great ones here, and I'm sorry that we haven't been able to cover all of them, but I think we've had a great discussion and, really rich and interesting. The one that sort of jumps out to me is one from Rayana Bu-Haka, who says, how can the resistance from pharma and private sector feeling threatened by the treaty be overcome? And how about adding a sort of a compact to ensure compliance? And I suppose, now she's mentioned that, it's something that I didn't, really get from the paper was, more sort of about the commercial determinants of health here and how that interacts with some of these compliance mechanisms. So it would be great to hear some of your thoughts on that. And Matt, I don't know if you want to start off with that, pick on you, so that may be a bit mean.
Yeah, I can kick off. So I think it's a really huge question. And look, the kind of at the heart of our argument here is that whether you most care about, ensuring that border measures are more rational, whether you most care about the sharing of information across borders in that way that Claire talked about and its roots that are so problematic and yet so very real, or you care about vaccine equity, which I think many of us have been deeply involved in. The core of this is that once the treaty is negotiated, we're not going to get better outcomes later. And our deep concern is that the current draft of the treaty envisions that a lot of these compliance mechanisms will come out of a committee that will be set up later and will somehow come out. And our core argument is that that is unlikely to happen politically. And so the most pessimistic among us can all also probably agree that the politics won't get better after passage. They never do. The politics will get harder after passage. And so this is the moment to include those mechanisms that might enable the kind of positive energy toward compliance that we want. When it comes to overcoming the objections of pharma and others, I think this is a huge challenge, right? And so one of the things that we know is that in negotiations, those have to be overcome, but also after negotiations, those have to be overcome. We're not going to see a moment where the European Union and the United States all of a sudden after this flip the script and somehow are going to have a different politics around these issues, right? And so there's gotta be a way for countries that are facing vaccine inequity to actually challenge that inequity, to have opportunities to bring that to the fore and political opportunities to do so. And then I hope that what will come out is, politically here, a strong, united global South front that says we will not actually move forward with a pandemic treaty that only plays into the dynamics that Claire was talking about, right? That only provides opportunities for the North to get what it's lacking without the opportunity for the South to get what it's lacking. And I think that opportunity to say it's in nobody's best interest to vaccinate the way we did during COVID-19. It prolonged the vaccine, it prolonged the pandemic. It'll do so again. We didn't use it effectively as a barrier. And then in the next pandemic, we might have a more effective vaccine and a more deadly pandemic, right? And in that setting, it would be even more of an issue that inequality results in further pandemics. And so it's not in the interests of the global North to have unchecked virus in the global South. We've seen that again and again and again. So the hope is that there might be an opportunity if the political pieces are aligned. Somebody mentioned the BRICS. There's a wide variety of alliances. If enough political energy comes into this, the hope is that the global South might come together as a bloc and actually say, we require good language there. And then if they do so, then there might be an opportunity to have it be enforced through good mechanisms here. And those mechanisms are not that hard. They're not out of reach. They're not things that haven't been agreed to in other forums. And in fact, Atiya talked about how effectively a bunch of these very soft seeming mechanisms, we just made a list, right? We made a gray list, a black list, and a white list, right? That's all we did. We made a list. But how powerful that is in the sphere of investment law, right? Well, let's use those tools in the service of equity, in the service of stopping pandemics, right? We've seen that countries react, and so let's use those exact same mechanisms that have been actually problematic in some of those settings to actually advance public health in other ways.
Thanks, Matt. Beautiful answer. Alan, over to you. You've got your hand up.
I know we are pressed for time, so I'll try to be very snappy and address two quick questions from David Patterson and again from Jean-Luc, who are various colleagues in the movement for human rights. I think linked to what Matt has just answered, there'll always be pressure from pharma, from private sector, and now to David's question from rich global North country or emerging strong countries in the BRICS, and there's not much that you can do around that resistance because, at least for the countries, it depends on what deals are being struck to see whether a treaty will be signed or not. And I think the aspect of whether one of the big countries don't ratify the treaty, I think from the dynamics I've seen with some of the negotiations happening with the pandemic treaty, there's been a lot of interest from some of the countries in the global South to continue combining forces because they see some important value of provisions of those particular treaties. So I think, in my view, and at least coming from the global South, if we can still get our countries to sign on, there may be benefits that come to the citizens in terms of being able to hold the governments accountable. It may be difficult to get the bigger players to ratify, and that's something that we may not be able to address here. But Jean-Luc, I agree with the observation that yes, we should not put our reliance on a specific dispute settlement mechanism, but it doesn't also hurt to have additional options on the table because you don't know when they're going to become relevant. I'm fully in agreement with you in terms of strengthening existing mechanisms, making more investments within existing mechanisms, because if the existing mechanisms are then enforced, you have enough judges, you have communities that understand, you've got well-financed special rapporteurs who can do missions. I think then the role of accountability can be played much better. And indeed, if WHO is made stronger and is able to play its enforcement role, that will also lead to some results. So I agree with your reflections, and it's a balance. And we are hoping that through the negotiations, we'll see some of these compliance mechanisms being considered and being added to the table so that it can be a chest of tools that people can be able to know when to deploy and how to deploy them. It's not normally easy to access some of these dispute resolution mechanisms. It's expensive, it's complicated, but again, we would need them, as we have seen with various things that have happened with the FTC. So I'll leave it at that because I know we are pressed for time. Over.
Got two more hands up from Matt and Atia. Atia, should we go to you? And then Matt, why don't you finish us off and do thanks? Perhaps that would be really great, or round us up. Atia?
Thank you. Sorry, Matt. So I agree with the conversation around that one type or one style is not enough. But I think we have to keep in mind that this is something new in health, and it's not going to sit the same way, and it's not going to fit the same way as it would fit in another area like tax or trade, where things have been settled for quite a while, but are still also very fraught with tension, frankly. So what I think and what I like as a solution is that all of them should be listed, then they should be then taken in turn and then tried out, almost even piloted. And sometimes some things will work better at a regional level than at a global level. So even as they are testing these tools, and this is why I think they should be listed in the treaty, is that at least you've not blocked them out, and you can even mention an any other or a combination of the above. We are lawyers, we can find terminology to keep it in, but having those options available and then contextualizing, I think that is something that's really important. So as much as treaty language can be very rigid from a legal perspective, this will allow for a lot of flexibility in enforcement and application. Thank you.
Thanks so much. Matt, over to you.
Just one final thought here, which is just I love this conversation, Gianluca, and this is where I think the rubber hits the road. Ironically, it's an interesting idea that we could strengthen and make more health friendly some of these other existing mechanisms, right? And I think that's a really interesting question. I guess I'm pessimistic about that, right? It says to me that I don't think, one of the challenges domestically is if you need the trade minister to get involved, it's unlikely that the trade minister is responsive to the health minister, right? It's unlikely that the finance minister is responsive to the health minister. And so my point here is that why not give some of these mechanisms that have worked in other spheres to the health sphere, give the opportunity for a dispute settlement mechanism, and spell it out explicitly. Others on this call and certainly Gianluca have far more knowledge and expertise than I do on kind of the IHR piece around the dead letter reality of the dispute settlement mechanism. But I would argue that it's not spelled out explicitly in a way that would make it actionable from day one, and that could be a real difference when it comes here. Final point just for me as we wrap up is just a huge thank you to The Lancet and to Jessamy in particular for all of the work that you all did to get this piece on, as well as to all the other co-authors, and to Elvin Nayakuri, Elise Massar de Fonseca, Sam Halaby, and Adi Radhakrishnan, all of whom could not be on this webinar but contributed immensely to the final piece. And thank you to everybody that's on. Over.
Thanks so much, Matt. Thanks everybody for joining us. It's been a great discussion. I'm sure you can continue the conversation on Twitter or somewhere else on some other platform. Please go ahead and read the article and share it. I think it's going to have, could have an enormous impact. So I will leave it there. Thank you so much. Great to see you all. Thanks to our panelists. Thanks for joining us.